You all got messages about it. Also, the governor put out an executive order number 63, which basically says face masks have to be worn inside buildings. So if you're going to hold an open house, you're going to come to an office or anything like that, it does require that you have face mask and take proper precautions. Open houses, no more than 10 people at a time, spread out 6 feet apart, mask, hand sanitizers, the whole works. So if you're going to hold a physical open house, remember that. Today we're going to go over changes to the laws for 2020. Most of them go into effect July 1st. I will warn you that there are 38 changes to laws. We will not get to all 38 today. This is going to be probably 3 sessions to get through all these laws and do it properly. We'll see how it goes today. I'm just going to start. You got the handout sent to you. I'm going to start and just go through them. The first one, House Bill 513. Now, if you want further information on these laws, we're going to discuss them. But I've done extensive research by going to the different chapters of the law, etc. You can do it one or two ways. You can actually go to the Virginia Legislative Session 2020, click on the site, go to Quick Links, and select bills and resolutions, put in the Senate bill or House bill number, and you can read the whole law, or you can click the link that's in that email for these different laws you have. There's a link that will take you there. So if you really want to know more about it, read the law. Some of them I printed all the law out, but I'm going to discuss some of it with you today. The first one doesn't affect most of you, death or disability of the broker. So HB stands for House Bill 513 if you wanted to do some research on it. The bill updates and clarifies that if the broker becomes incapacitated or dies, who can close the business down. They can do it for 180 days. If you are working for a firm that the broker passed away or became incapacitated, no other broker to step in, then the person could close the business down, whoever's appointed, but they cannot do any new business. So hopefully you're never involved in that situation. This number 1.2 here under license. The bill expands the current law, and I'm going to mute everybody now so that we don't hear background noise. When you want to ask a question, just unmute yourself. Okay, so the next one, spouses of military members and veterans. In the state of Virginia, the military is a very, very big part of our real estate business. So Virginia does everything they can to protect and promote that industry in the state of Virginia. So this one, if you are a spouse of someone who is transferred into Virginia, okay, and the law used to say they had to be stationed in Virginia. They've expanded this now to be DC, Maryland, surrounding locations. So if you're living in Virginia and stationed somewhere else, you're still covered. That means the person literally can come into our state here and do real estate if they were licensed in another state with a provisionary license to give them 12 months to meet any other requirements. So it makes sense if this trailing spouse is coming in and they had to go through the licensing procedure just to get started. They might be transferred out before they could ever actually work. So those two are pretty much housekeeping. And when it comes to business licenses, okay, number 2.1, House Bill 466, okay. this allows them to not charge business license tax of people if there's 50,000 or more and over $200,000 in income. When you get your checks for your commissions, you'll notice that there are BPOL charges tax taken out, business professional occupational license tax. What they have done with real estate agents, they have said, we don't want to have to go and collect money from every real estate agent. So the company is made responsible to collect the tax and forward it. So this one probably will never affect any of us in Northern Virginia. The tax is taken out, the company pays it. You should be taking it off your income tax when you pay your taxes. The next one, 2.2, cell phones while driving. Now, all laws in Virginia usually go into effect July 1st. This one doesn't go into effect until January 1. And it's going to be illegal to hold a handheld personal communication device of any sort, okay? So if you need to make a phone call, you need to answer a phone, text, whatever, you've got to pull over, get off the road, and park, okay? So you're going to have to be hands-free completely. And quite frankly, I do not talk on the phone when I am in the car, text, or do anything else unless I am completely parked. It's hard enough driving around Northern Virginia when you're paying full attention. So please be careful. So one of the exceptions in the law, it says, if you look at the law, an operator who's lawfully parked or stopped, that doesn't mean at a traffic light, okay? So pull over and take care of that. The fines for that, $125 for the first, subsequent fines, $250, and it's an automatic fine to be on your phone, period, in a work zone. So it can actually be a reckless driving charge if you were erratically driving because of your talking. You don't want to have a reckless driving charge. Worker misclassification. This one's interesting. The state of Virginia evidently is losing a lot of money from workers' comp and not being paid for everybody because everybody's come all of a sudden a 1099 employee. So this law talks about where you have to be concerned. If you have members on your team, you have team members, and you have been treating them as a 1099 contractor. Well, this new law says it creates a presumption that the individual performs services for pay is an employee unless you can prove they're an independent contractor. And that's in reference to Internal Revenue Service guidelines. It also, now, if that party felt like they were an employee, they would have the right to come back and sue you for any damages they received because they had to pay their own fees, etc. So be real careful by July 1. If you have team members, make sure that they are classified properly. You remember last year, the law actually changed to say that you could have people on your team as independent contractors as a licensee, but they would pretty much have to be set up with a company. So be careful with that. You don't want it to come back and have to pay back taxes on anybody that was working for you that they classify otherwise. The next one with worker misclassification, House Bill 1407, this one becomes effective January 1. Virginia Department of Taxation is now given authority to investigate and go after people that are misclassified. So what does this mean? Um, probably a whole lot more investigation into this, because they can collect fines of 1,000 first offense, 2,500 second offense, etc. So most of you aren't affected by that, but if you do have people on your team, make sure that you classify them properly. The next one, 2.4, House Bill 1244, Senate Bill 812. This deals with illegal calls. So currently, Virginia law puts restrictions on calls made to wireless telephones. These bills add protections for your landlines if you still have them, and text messages sent to wireless telephones in a Virginia area code, or to someone who is registered, phone registered to a person who's a resident of the Commonwealth. So the $500 for a first offense, $1,000 for a second, $5,000 for each subsequent. So this means you really have to be cognizant of the do not call laws. Virginia has a do not call law. They have a do not call registry. And this is even for people that are making calls on your behalf for marketing. So make sure that you don't want to fall into the trap of this do not call act, okay? Common interest communities. Okay. I had some questions about this week. And remember, these don't take effect until July 1st, okay? Common interest communities, 3.1, House Bill 176. We've had quite a few changes to our POA and condo. With this one, to extend the 3-day right of rescission up to an additional 4 days. So what does this mean? The parties have the right to cancel the contract anytime, and I mean anytime, up until they receive the documents or until they receive them, and they have 3 days if they were hand delivered, 6 days if they were postmarked from the post market mailed, to walk for any reason whatsoever. They don't have to give a reason. Well, this new law says if it's written into the contract, actual term in the contract or an amendment to a contract, they will have up to 4 additional days to review the documents. I sort of like it. So that people actually, my daughter just bought a house out in Lake Tahoe out in California, and she called me and she said their documents were 200 pages long. So California is really into it. 200 pages, and they had 3 days to get through it. It takes me a while to read, so I could use the additional 4 days, but it's not automatic. It has to be agreed. Also, this does not mean that you could have less days. You can negotiate more, but the 3 days is the default, and it cannot be made less. So I pulled out chapter 121 of our statute, and I just want to go through it briefly here. And this deals with these documents and the delivery. They talk about a ratified real estate contract, and that includes any addendum also, okay? It can be extended from up to 7 days, so 4 and 3, if extended by the ratified real estate contract or an addendum afterwards, okay? Now, the 6 days, it's 6 days after postmark. So if these are being mailed, the 6 can go up to 10 if everybody agrees, okay? In the 6, it just makes assumption that it would take 3 days for it to get there, and then you would still have your 3 days to review. But mailed, it's 6 days from postmark, but that will be up to 10 now if you extend. Now, for purposes of this act, it says that you have to receive the documents or a notice of non-availability of the documents. So the association disclosure packet is deemed not to be available under these circumstances. A current annual report has not been filed by the association with either the State Corporation Commission or the Common Interest Community Board, or the seller has made written request to the association that packet must be received within 14 days, okay? Or if there's an actual written notice provided by the association that the packet is not available. Those 14 days are not adjustable, okay? If we're getting close to 14 days and you haven't received this package, get in touch with that company that's handling this and say, look, we haven't received these documents. We're pushing the 14-day time period. And if you're not going to get them to us, then I'm going to report you to the Common Interest Community Board for failure to deliver them, because it means now they're deemed not available. And what does that mean? That means your buyer then has 3 days, okay? 3 days to void their contract for not receiving the documents. Now, let's make sure we're clear. It's not 14 days from date of ratification. It's 14 days from the receipt of the written request by the management company to deliver the documents, okay? And that time period, once you receive them, can be extended. Now, I get this question quite often, so I just want to give it to you from the statute. The purchaser may also cancel the contract at any time prior to settlement if the purchaser has not been notified that the association disclosure packet will not be available and the association disclosure packet is not delivered. If they have not received a written notice of non-availability, okay, all the way up until the time they receive these documents, they have the right to void the contract. Okay, I've had agents say, well, nope, they got to wait till they receive them. Well, that wouldn't make sense, because what if the seller never delivered them? Then the buyer could never get out. So that language is there. But once you receive that written notice of non-availability, then you have 3 days to cancel. One of these sessions, we're just going to go through this whole 121 and make sure everybody completely understands all that to do with that. Anybody have any questions about that one? So in order to extend, it has to be written in the contract or an addendum to the contract. Good. 3.2, House Bill 720, display of political signs in HOAs. So this bill adds an item to the required disclosure packet requiring POAs to include a statement setting forth any restrictions as to the size, place, duration, or manner or placement of political signs on a lot. Elections coming up, probably they want to make sure that they can still get their signs out there to be able to get your vote. I don't care one way or the other. I've never lived in a homeowners association other than this condo I have in Florida. And part of the reason is I don't like to be told what I can do and can't do with my house. So still a rebel from the 60s. We don't like a lot of rules and regulations as baby boomers, and that's probably not going to change for me. Okay. All right. Fair housing. Now this gets interesting. We have, yes.
I'm sorry.
No problem.
If you have to report the HOA people, the subdivision, they are not giving us the information, where are we supposed to report them?
If you go to DPOR's website, DPOR, your licensing authority in Virginia, and then you would go to the common link, click the link for the Common Interest Community Board, and that's where you would report them. Common Interest Community Board is in control of licenses for management companies for these homeowners associations and condos.
Thank you,
Okay.
Larry.
Okay. You might want to visit that site sometime, Common Interest Community Board, and see some of the firms that have been, they've been fined and people lost licenses, etc. But you also need to go to that site for the purpose of making sure that reports have been filed and all for your own association that you live in it. Okay. Under the Virginia Fair Housing Law, okay, they are changing one of the changes. It will no longer be called handicap in Virginia Fair Housing Law. That will be called disability. Once again, this doesn't take effect until July 1. I love it when they make these technicality changes, and then I pull up their law that shows the changes, and they're still calling it handicap. So I've sent an email off to my representative from my district and asked them to see if they can get that taken care of before they issue this law. But now covered, the protected categories in Virginia will be race, color, religion, national origin, sex, elderliness, familial status, disability, source of funds, sexual orientation, gender identity, and status as a veteran will all be protected under our Virginia Fair Housing Law. So we're going to talk about each of these as we go through. And then if you have any questions, please don't hesitate to ask, because when it comes to fair housing, you don't want to get involved in any kind of a hearing for that. So the one that's probably the one that's going to cause the most consternation would be 4.11, source of income. Okay. And source of income is just like it sounds. Section 8, as we call it, any kind of assisted housing, your landlord will have to accept it. Now, the caveat with this one is that they have to own 5 or more rental properties. So if you don't own 5 or more, you wouldn't be bound by this. But ownership now is defined, and I'm glad they finally gave us a definition. That means 10% interest. If you have at least a 10% interest in a property. So even if you set up each property as an individual corporation or whatever way you want to do it to protect your liabilities, if you own at least 10% interest in each one of those, then that counts. So the properties do have to be in the state of Virginia. The other caveat, they have 15 days from the day that their lease is accepted to get approved for that money. If it goes past 15 days, then your landlord does not have to accept them. Okay, so source of income will now be protected. It is more than 4 rental properties. A little different than tenant landlord. Tenant landlord, everybody's pretty much covered under tenant landlord now, but this is fair housing. Okay, so I took
Larry,
a look
what
at
is the 15 days? You said if they are not putting a.
Once the lease is approved and they are going to be using subsidized funds, they have 15 days to get the approval for the subsidized funds from the provider, whether it's the government or a private agency or whatever. They have to have in writing the approval that they have those funds within 15 days. If not, then your landlord could say, I'm not taking you as a tenant, because it doesn't make sense for your landlord to keep their house off the market more than 15 days while they're getting their funds. So they may be approved, but then the property has to be approved for these subsidized funds. So if it's going to be more than 15 days, then your landlord doesn't have to wait. Okay. So source of funds be a new protected category. Sexual orientation and gender identity. I know it's just a matter of time. I thought the federal law would beat Virginia, but under Virginia Fair Housing Law now, sexual orientation and gender identity are a protected category. And it was interesting how they did it, because they didn't directly do it with the Fair Housing Law. They put this under Chapter 1137 of our statute, which prohibits discrimination in employment, public accommodations, public contracting, apprenticeship programs, and housing is included there, banking and insurance. So sexual orientation and gender identity have been added to unlawful discriminatory housing practices through Chapter 1137. So our code of ethics already included sexual orientation and gender identity, but now your statute beginning July 1st will cover it. Okay. Also protected here are veterans. They are now protected. So sometimes I know a lot of people I knew came back from Vietnam were, not treated with the highest respect that they deserved, etc. So if you're a veteran, you cannot be discriminated under fair housing now. Okay. Any questions about those new categories to fair housing? Good. I want to take a look now at restrictive covenants. This gets kind of tricky. Okay, restrictive covenants gets kind of tricky here. Under this bill, no deed recorded may contain restrictive covenants that violate the Virginia Fair Housing Act by restricting ownership or using property based on a protected class. So if you have a deed that restricts, I know I used to use an example in some of my fair housing classes that back when George Washington freed all of his slaves, he gave them land all around Mount Vernon. And in the deed, it said no whites could ever own the property. Well, that became unenforceable under our fair housing law, but now that deed would not be recordable under our fair housing law. So I remember when I was packaging up Madison Lane at Bailey's Crossroads, the deeds, no Jews and no blacks could ever own the property on Madison Lane where I grew up, and that would not be enforceable. It remained in the deed, but now any deed that's drawn cannot contain any of that language, and it's the responsibility of the attorneys to make sure it's not in there. They have come out with language now for what is required in the form of a deed. That does not affect us too much. But if you're at a settlement and you see a deed that has any of these restricted clauses in them, I would bring it up. It doesn't make the deed unenforceable or not valid, but they should be using the new language. And there's something called a deed of reformation. Actually, the developer that bought this land that we had packaged together would not settle until we went back and got everybody to agree to read new deeds on their property that took out this offensive language, because he knew it would have to be transferred in each one of those townhouses because it ran with the land. Now you can file a reformation deed. If you have a deed that has that language in it, you can file to have it removed, and you do not have to pay any additional recording taxes or anything to do that. So that's a good one, I think. Okay. The next one, 6.10, expungement of unlawful detainer, all this stuff here for tenants, I am going to put off till next week's session because I want to do all that at one time. So all the property management stuff we are going to take up with next week's session. So I want to go forward to Residential Property Disclosure Act. Some interesting changes to this Residential Property Disclosure Act. Okay, we have what you're going to have to pay attention to here. July 1st, there's a new requirement, and the new requirement is the form signed by the buyer that you have told them that they need to go to this site. It takes it a step further now. It says that the buyer has been advised of the disclosures, okay? So if they've been advised of the disclosures, so if that's the case, you're gonna have to know what's protected and not protected and actually go over that so that they do not have the chance to come back and say, well, no one ever told me about this stuff. Okay, so if you have a property that's listed right now, you go under contract before July 1st, you use the old disclosure acknowledgement form. Okay, if it settles after July 1st, you don't have to get the new form that comes out July 1st signed. Okay, what you do, but if you have a listing that you already have the old disclosure signed by the owner and it goes under contract after July 1st, you will need to replace that with the new disclosure form. So if you're not under contract by midnight on the last day of June, get the owner to sign the new form to have with your contract package, okay? Because there are some real changes to this statute. So the fact that they said you don't need the new one, if you already have that, is great. I mean, because every time they change this, there's confusion. Do I have to have the new form, the old form, etc.? Okay. So some of the changes to this. There are 5 mandatory disclosure forms that we have talked about in the past, correct? One of them was Chinese drywall. The Chinese drywall will no longer be a single disclosure form after July 1st. So if the owner knows they have Chinese drywall in their property, that is a single property disclosure till July 1st. After July 1st, it will become a I'm not telling you. So they're removing that from not only from a mandatory disclosure under POA, but they also removed it from our agency act, which said, the agent had to disclose if the owner had Chinese drywall. So that has now been removed from both places and made one of these I'm not telling you I have. Okay. So the bill updates the disclosures in the POA Act to remove the statement that the owner is making no representations or warranties with respect to any presence of any stormwater detention facilities. So now the Chinese drywall has been replaced with an affirmative disclosure if they have a stormwater management facility located on the property. They have to disclose the long-term maintenance and inspection requirements. So there will be a new one-page disclosure added to take the place of the Chinese drywall, which will now be, I'm not telling you. So the way I counted it up, there will probably be now 17, I am not telling you I have these as an owner. You need to go and go to this site and check these out. But you probably need to make sure as a buyer's agent, especially, that you discuss these briefly with the party, because the law, remember the law says that you've advised the clients of the disclosure, not just that they should go to the site. Okay. So be a new one-page disclosure form for the acknowledgement of these stormwater
Larry,
management on the site. Yes.
what year they were using the Chinese drywall? So at least it was it's a flag for us when that when we see the property, we know that we be better careful to check it out or discuss it or be more careful.
Well, the Chinese drywall was kind of tough to know if you had it. If they didn't know they had it, literally didn't know they had it, most people would never know. About the only way you could have known is go up into the attic, pull the insulation back, see who the manufacturer was and where it was manufactured. The nice thing that I liked about the disclosure form for Chinese drywall, and you might want to download it if you don't have a copy of it to keep, because it'll go away July 1st. It explained the dates that you might find this in your home. So if your house wasn't built during that time frame, you probably didn't have it. So download that form, just be familiar with the Chinese drywall. But it's going to be one of those now that they have to go and check out on their own. Okay. Now, you'll see under 7.3 here, there's some new disclosures being added. And once again, they just didn't say, okay, this is going to be added to the POA. They put it back door in through some other laws, but all these will now be on that I'm not telling you I have or whatever in my home. So some new ones now that you're going to have to be aware of that your buyer should be checking out. Lead pipes. Okay, lead pipes, and you know, when I bought my first home in Arlington down on the South 8th Street, the drinking water came into our house through lead pipes. So this one's going to be pretty found in a lot of properties, I think. As to the disclosure statement, required to be furnished by the owner of residential real property to the buyer, that the buyer beware and exercise necessary due diligence with respect to whether the property contains any pipe or plumbing fitting, fixture, solder, or flux that does not meet the Federal Safe Drinking Water Act definition of lead-free. The bill also requires any licensee who is engaged by a landlord and who has actual knowledge of the existence of any pipe or plumbing, etc., that they are going to be, they have to disclose to the prospective tenant. Okay, but once again, this is our law says we only have to disclose that which we know, and not what we should have known, could have known, or might have known. So if you don't have actual knowledge, you'd be okay. But if you're, once somebody's put out a notice that this is there, you're going to have to make sure you disclose this now under disclosure law. Marine clay. They've added marine clay. I know down in, years ago, when I was young, about 17 or 18, down in the Fort Hunt area, my father owned a construction company, and we actually went in to take down some houses that were sliding down the hill from marine clay. So this is putting everybody on notice that, hey, the seller's not telling you if they have marine clay. The agent doesn't have to tell you unless they actually know. So this one now is saying the owner makes no representations whether the property is located on or near deposits of marine clay, and purchasers are advised to exercise whatever due diligence a particular purchaser deems necessary. So, and that means they may need to go to the local authorities to see what records are out there, or talk to a qualified professional. But once again, this is something that the buyer beware. Radon gas being the same way. It is now going to be on that I'm not telling you I have list. And then there will also be that affirmative 5 that we've always talked about. So radon gas is being added. The residential building energy analysis, this goes back to green, etc. But if they want to know about property and all that type of stuff, they need to get it inspected themselves. Defective drywall, removed from a mandatory to, I'm not telling you I have this, you really should check it out. And dams on property are the same way, okay? So these are all changes to your Property Disclosure Act. Any questions about any of those? You should be familiar with them. You can pretty much find them in the disclosure law if you download it, but we'll do sessions on each of these subjects later on. Any questions about any of those?
So when
Hi,
we put in
Larry.
an offer, we have to, is a special form, we have to put it with the offer to send it?
The new form will come out July 1st. It will be put out by DPOR. So we'll probably have it in our hands before July 1st. I'm sure NVAR will have it on their site. And it's just a change in the language that you have been informed of these instead of you should go and check it out. So
Thank
I
you.
would probably discuss them, but you still use the old form until July 1st. So whatever you already have in your listing package now is fine. If it's not under contract by July 1st, then add the new form. Anything you list after July 1st, use the new form. Okay. Somebody else had a question?
Yes. Hi, Larry. This is Jason. Thanks very much for the very informative talk. I have a question regarding the new requirement on the source of income you just mentioned. I remember there are some websites, for example, I don't remember if it's Zillow or Zapper. They actually ask you to check if you are interested in accept, for example, Section 8 tenants. And
Yes.
so if the law applies after July 1st, you have to check that, or how do we handle that?
Well, if you don't own at least a 10% interest in 5 or more rental properties located in the state of Virginia, then you could still say no.
Okay.
But if you own at least 10% interest or more, then you'd have to say yes.
Okay. Okay.
Because now it's going to be part of our fair housing. Right now, Section 8 or a source of income was not protected under fair housing in the state of Virginia. So if it's not protected under the fair housing, you could turn it down because it was a program.
Yeah, but you can still turn those things down. You know, you can have a fair review, and based on other criteria, you can turn down or review.
I mean, if they don't qualify otherwise, but for the source of income, you can't turn it down.
So you cannot just say we don't accept the Section 8 anymore.
Not if you own 5 or more properties, at least a 10% interest.
Okay, great. Thank you.
But once again, that starts July 1st.
Yeah. Great.
Larry, when you're saying a 10%, what do you mean? If the house is a cash and it is,
no,
making more than
ownership.
No, this is your ownership. So if you have a corporation that you set up, and a lot of people set up an LLC or a corporation, and so if I own 123 Main Street, I might call that 123 Main Street LLC, and I might have 125 Main Street LLC. But if I own the LLC, or at least 10% of it, that counts as one property.
I see.
So you no longer be able to say, well, I don't own 4, these corporations own it. So they're saying at least a 10% interest in a property.
Okay, but if it is yours and it's 100% yours.
So what it boils down to, if you have a landlord that has a bunch of properties and they're telling you no Section 8, you might not want to take that listing until they get some legal advice. Okay?
Okay. Just show them the law.
Yeah, show them the law. We don't write them. We just have to go by them.
Yeah.
Right?
That's good to know. Thank you.
Okay, we have some miscellaneous stuff here. 8.1 septic inspections. This just deals with the people have to be licensed in order to actually do these inspections. So make sure the parties that you hire do have a valid license as required under this new statute. Okay. I 8.2, I'll come back to next session. There's a couple things here that I want to cover. I'm just about out of time, and we'll do more of these laws next Wednesday. But 8.3, the grantor's tax. You know, the seller, if in certain jurisdictions, have to pay an additional 1% transfer tax. Well, this new law allows the buyer and seller now to agree that the buyer could pay that 1%, or they could agree to split it. They could agree to do all kinds of things. But if it's not mentioned in the contract about this agreement for this tax, then you're going to, it's going to default back to the seller, which, you know, I always thought wasn't fair. If I'm a seller and I'm leaving the area, why should I be paying for future improvements to transportation? It should be the people, you know, benefiting from it. So now I could say, look, I'm leaving the area. You want to buy my house, you're going to have to pay that tax. And you might get away with it in a hot market or in negotiating. The buyer's agent might now use this as a negotiating tool. After July 1st, my buyer is willing to pay this 1% for the transfer tax because they will be benefiting from it. Interesting part is only half of the money stays in Northern Virginia. The other half goes to the rest of the state of Virginia for their roads. So even though we're paying for the tax, we don't get it all. Also allows 5% to be taken out, 5% of the total money taken out to pay the clerk of the court for recording. So be well aware that the grantor's tax. And I'm going to leave you with this one. Beginning July 1st, any rent or money that you get has to go into an escrow account. We will no longer be able to keep that first month's rent and put it directly into our accounts. Anything that comes in prior to when the money is to be used must go into an escrow account. Okay. So I am going to stop here because I try to hold these to an hour session. We have, you know, several more weeks before this stuff goes into effect. I'll let you digest that, and then we will come back next Wednesday at 11, finish up the rest of these laws, plus the laws for property management. Any questions, any other questions about anything before we call it a day today?
Yes, for the escrow account, for the rent.
Uh-huh.
I usually put them in my account. Now I have to open an account for it?
It would have, no, if you have money that's coming into your possession as an agent for somebody else, it will have to go into an escrow account.
Okay, I thought you were talking about the rental.
No.
Okay, thank you so much.
Larry, you mentioned some handout.
I'm sorry.
Larry, you mentioned some handout will be emailed to us. I haven't received any email. Do you have something like the handout of those lectures that you already gave?
If you did not receive the email saying that this was going to take place, you haven't received any emails saying that the session is taking place?
I did receive the email.
Okay,
yes.
well, embedded in that email with my picture and all, there's a place for you to click to download the materials that we'll be using that day.
Oh, okay. Okay. All right.
Okay. If you see it there, you can click it. And if you want further detailed information, and when you click on that, that comes from VAR, Virginia Association of Realtors. You can actually click on the bill link in each one of those, and it'll take you to the law.
Okay. Okay.
So you can read the full law.
Larry,
Yes,
excuse me, about section 8, you were referring to if you own 4 or more rental
more
properties
than, it would be five or more if you
5
have
or
a,
more in Virginia. But
In Virginia.
previously you were referring to a county. So each
No.
county was,
no, that's tenant landlord.
uh-huh,
This is not tenant landlord. This is fair housing.
I see.
Okay.
Okay.
So, and so fair housing, this says if you own at least a 10% interest in 5 or more properties, because the law says more than 4, so they just go ahead and say 5, at least a 10% interest in 5 or more properties, then you are bound. If you don't, then you're not bound by the fair housing part
I
of
see.
this.
So state of Virginia, it
Yes.
doesn't
So,
matter
so
which,
if you own 2
which
properties
county.
in DC and 3 in Virginia, well, you only own 3 for Virginia fair housing law. You don't own 5 because 2 of them aren't in Virginia.
Right.
Okay, so the properties have to be located in Virginia.
Thank you.
Okay.
Thanks.
Any other questions today about anything before we call it a day for today? Because Pool's beckoning me down here in Daytona Beach.
Larry, it would be a good idea to just tell everybody that if they get one of those crazy mails saying that the session was canceled, it is not true. They will continue every Wednesday at 11 o'clock.
Yeah.
All
So
right.
I don't know what happened, why an email went out. Some people may have received it, but we ended up with 38 or 39 people. So that's a good turnout. Please let other people know we're doing this. And these are recorded. So embedded in that email is the site that you can go and watch previous sessions of this. Okay.
Thank you.
Well, thank you everybody for joining me today. I appreciate it. And I know Johanna and other managers, I saw Kevin was on here today. So, please spread the word. And let's look at the rest of these new laws next week and discuss any that you've had time to look at from today. And we'll see you next week.
Thank you.
Sure.
Thank you.